So welcome again, understanding the basics of the Clean Water Act and Ag, impaired waters and TMDL processes. My name is Audry Thompson, and next slide there. The Understanding Agricultural Law Educational Series is a course designed to provide subject matter literacy and competence on fundamental issues of agricultural law to attorneys and business advisors who work with or represent agricultural or rural clients, but who may not necessarily specialize in ag law. This series is wholly sponsored by Pennsylvania Department of Agriculture's Ag Business Development Center, established through the 2019 Pennsylvania Farm Bill. The Ag Business Development Center aims to enhance the long-term vitality of Pennsylvania farms by supporting farm transitions, both from generation to generation and from conventional to organic, supporting beginning farmers, providing risk management education, and providing financial assistance through low-interest loans and grants. Next slide, please. We've covered many topics in this series so far, including ag cooperatives, finance, farm credit, ag labor, conservation programs, Pennsylvania's Clean and Green, and many, many more. You can find the materials for all of that at our Understanding Agricultural Law landing page on our website at aglaw.psu.edu. Next slide, please. So we encourage you to mark your calendars and register for our upcoming programs here. On April 25th, we've got Pennsylvania Ag exemptions for inheritance tax and real estate transfers. I think it's going to be a really, really good program. May 30th will be Migrant and Seasonal Agricultural Worker Protection Act, more labor there. June 27th, Pennsylvania's Clean and Green program. This will be kind of an advanced topic looking at county level administration. Then in July 25th, we'll have ADA compliance for agritourism operations. And then in August, foreign agricultural land ownership laws, a survey of that and how, what's going on in that arena there. All of those programs are Fridays at noon Eastern Time. Registration is available from the Understanding Ag Law landing page and our events page, and Attorney CLE is available. Next slide, please. We've also got the quarterly dairy legal webinar series. Our next webinar there is going to be next month, April 15th. That's going to cover bovine disease controls, federal and Pennsylvania laws and regulations, as well as a roundup of the regulatory and legal developments affecting dairy. On July 15th, we'll cover the second quarter of 2025. We're working on the focus topic there. We'll let you know. But both of those are available for registration, and Attorney CLE will also be available. And next slide. We've got two programs this summer lined up with our partner, the National Ag Law Center. This is through the National Ag Law Center. On May 21st, Jackie's going to talk about navigating ADA compliance for agritourism guests. And then on June 18th, our directors, Ross Piper, will talk about an overview of state grain dealer statutes in the United States. You can get to NALC's registration from our webpage on our events there. And to my knowledge, I don't think Attorney CLE is available for those programs, although that would be through National Ag Law Center. And one last slide here. One last plug, mark your calendar, save the date for our 2025 Agricultural Law Symposium. That's going to be in person at Penn State Dickinson Law and University Park on Thursday, September 18th. I'll put the events. You can get everything in the events. So many tech things going on here. I sent the wrong message. I'll fix it all. So that's up. It's just to save the date. We're working to have registration here within the next month, so we'll get that going. All right, and then finally, let me see if I can put things in the chat correctly. Again, I apologize. We're going to chat to everybody here. This webinar is being recorded. If you have questions, use the Q&A. We've got some surveys that we'll put up later in the program. And then if you're going to submit this for CLE, I just put a link to a CLE form in the chat. I'll put that link in for that form many more times. And actually, since I fixed this, let me go ahead and here's that events page. Here's our events page there. You can reach all the events there. We encourage you to fill out that survey. Tell us what you like, what we can improve on. And sorry, I interrupted myself. CLE credits, if you want us to submit for CLE, we've got a form there. We're also going to give you a code word near the end of this webinar. You're going to need to put that word into the CLE form to get your credits. If you're on the phone, you can send me an email at aet17@psu.edu. That's Alpha Echo Tango 17 at psu.edu, and I'll get that to you. All right, I will deal with all of the issues here, people trying to log on. I'm going to turn this webinar to Brook Duer, the Center Senior Staff Attorney. Brook joined the Center for Ag and Shale Law in 2019. Before coming to the Center, he was the Chief Counsel for Pennsylvania Department of Agriculture, and before joining PDA, he practiced law in Lancaster County for 18 years. Brook, tell us about the Clean Water Act.
Okay, thank you, Audrey. Let's get to our next slide. Okay. All right, so this is our second in this series, this Understanding Ag Law series on the Clean Water Act and ag. And this one is going to be focusing on impaired waters and TMDL process. And I'll get it right out on the table at the outset here. We will not be talking about the Chesapeake Bay TMDL. Our intention here is to provide a and I'm watching the participant number drop down as I say that. No, went back up. We are going to talk about the process for establishing a TMDL, and this goes all the way back to the origins of the Clean Water Act in some ways, and then has a long history. Actually, despite the fact that we live in Pennsylvania and we are inundated with the Chesapeake Bay TMDL, the TMDL world, at least in terms of controversial issues and I think it's very quiet right now, really. But this is a general topic from a 40,000-foot view of the Clean Water Act, impaired waters, and TMDL process, not focusing on any particular TMDL. And it's just good because we live in this world where we live under this TMDL that is so convoluted and has such a strange and circuitous life history, so to speak, that it's kind of nice to maybe turn back and say, well, what are these things supposed to be like, or what was the intention? And boy, that's a pretty loaded question. What was the intention? But we will try to sort through a little bit of that, and then we'll wrap up by maybe talking about where things are going and what will this process come under the microscope for some type of reform someday, which has been said many, many, many times as something that's necessary. Anyway. I love this photograph here of this body of water. So I love to use this thing. Just makes you feel good. Okay. So the impaired waters and TMDL process. This all arises from what's Section 303D. These environmental attorneys and they love to refer to everything as by their numbers, and so hopefully I don't fall too far into that. I like to use words rather than numbers. But in any event, 303D is the section of the statute as enacted. Of course, the U.S.C. number is different. It's 1313D. But in any event, it provides the legal authority for EPA to require states to identify impaired waters within their jurisdictions. Impaired waters is a term of art, which we will discuss, and to approve a total maximum daily load, a TMDL, or pollution diet or pollution budget for those particular waters. Maybe my waistline says I shouldn't use the word diet. I'll say pollution budget. Now the Chesapeake Bay TMDL spans, of course, 6 state jurisdictions in the District of Columbia and is the single largest TMDL in U.S. history since the Clean Water Act, as we know it, was enacted. But there have been, and there continue to be, thousands of other TMDLs established and implemented since approximately the 1990s. We'll talk about there was a delay between the enactment of the Clean Water Act in 1972 and the TMDL process really got no attention for the first couple of years, 20 years. And there weren't even any regulations until 1992. And this webinar will hopefully help you understand the process by which it occurs that TMDLs are established and implemented. And of course, there are thousands upon thousands of TMDLs that have essentially been closed because mission accomplished, so to speak. And so there's a lot more to TMDLs than what we're dealing with in the Chesapeake Bay. Here is a slide that has many, many resources. The first 6 are just EPA web pages, some of which cross over and go back to each other. It's very labyrinthian when you get on the EPA's website. But in any event, you take a look at these pages, you're not going to miss anything. And I will say, to EPA's credit, they have a just a ton. I mean, there's the description of a ton of information. This is the topic upon which that really fits. And it's explained in so many different ways, and on so many different web pages. Same thing many times, but sometimes that's not so bad. And then I've sort of cherry picked a set of CRS reports that deal with TMDL processes. Two of which here are about the Chesapeake Bay, because, hey, we're all from Pennsylvania, presumably, or pretty close to, or we're all from Bay states, let's just say. And then there's one just about, algal blooms, which, of course, is something underlying a lot of this when you're talking about nutrients from agriculture, primarily, making their way into waterways and then becoming the subject of a TMDL. So love the CRS reports. I mean, if you're not a person who gravitates towards CRS reports, Congressional Research Service, these are written for congressmen or Congress staff, or and the public, of course. But I mean, these are like a gold mine if you don't use them. They're just, you want to know something about federal government operations or federal law, that's the first place to go. Okay, now, as I mentioned, this is the second in our series here that's about the Clean Water Act. So this is the first one, was back in June of last year, and here's a link to it up here in the upper right-hand corner. So you can go watch that, and it could be helpful, but I'm going to do a really quick recap. Of course, I started with the beginning of the Clean Water Act, which is historically and irretrievably linked to Lake Erie is on fire, which of course was an incorrect characterization of what was happening back around 1970 or so, 69. It was actually the Cuyahoga River that was on fire, but Cleveland probably never lived that one down. So in any event, and there's of course an actual photograph of the Cuyahoga River on fire, and that is always credited historically as the genesis or the impetus for the Clean Water Act, which of course was a massive change in federal policy in some ways, and I will just go over that. Okay, so the Clean Water Act history, of course, it technically enacted in 72, and it was really, the underlying statute's still there, the Federal Water Pollution Control Act, that goes way back much further, and then the amendments that occurred in 72 just become collectively referred to as the Clean Water Act. In fact, I believe that it was by statute in 77 officially designated as the Clean Water Act. There's a link to it and everything. Now, but prior to this, basically the Clean Water Act was all about ambient water quality standards being employed that essentially specified acceptable levels of various pollutants in a state's interstate navigable waters, the waters of the United States. It was just a test of, take a sample of, and it was not about, tracing the source of any of these things. It wasn't about, remediation of, at the source. It was all about just, there's this big body of water, and here is the average levels of pollution in it. That's what you needed to address. The aggregate level of pollution in the body of water as a whole, as opposed to going back and trying to deal with the preventable causes of it. So that's the big revolution of the Clean Water Act. And, basically what the 72 amendments introduced was, and this is what we went over at great length in the prior seminar or webinar, was, basically two objectives now. Regulating discharge of pollutants into the waters of the United States. That, of course, is implemented by the MPDES system. And I'll get through this slide here in a second. And then there was a second objective, which was regulating water quality standards of surface waters. And that was what we covered the first webinar, except, it was really all about the MPDES permitting system for, point source discharges, and then there are some others that get lumped in. So the new approach was, again, setting effluence limitations, meaning standards for the discharge from your pipe, from your point source, whatever it may be, and creating them to tailoring them to specific industries and specific types of pipes, so to speak, and governing the rates and concentrations and everything. Okay, and that's the National Pollutant Discharge Elimination System. The NPDES permitting system is what served that purpose and accomplished that purpose. And now we're going to go back and we're going to talk about this second objective, which is regulating water quality standards of surface waters, which is including equally point source and the non-point source, which we talked about at the last webinar, which is anything that's not a pipe that's going into a water of the United States, essentially discharging something. So, it's all that other atmospheric stuff, whether it's rainwater, stormwater flowing in, whether it's air deposition of, substances, into water, which is a giant issue. And, all the other ways that things find their way into surface waters. So that's what we're going to talk about. Clean Water Act regulation of water quality standards of surface waters. And that is where the TMDL process comes into play and the concept of an impaired water. So we'll talk about it. Basically, there's three functions, three things that states have to do. And again, this is now, unlike the NPDES permitting system, which we talked about, which was all about point source discharge actors, shall we say, who are responsible for point source discharges. Sometimes they could be government, but sewer treatment plants, etc. But of course, it's private landowners. That there's the focus and the permitting system, and that's how the government keeps track of what they're doing and can potentially have some enforcement authority and all those kind of things that go with having a permit to have your pipe discharging into a water of the United States. Now we're talking about a whole nother game. We're talking about states being obligated to do things and being, to some degree, and to what degree is the big if, answerable to the EPA. So this is now the state as the party who has obligations, let's just put it that way. So states basically three functions: establish water quality standards, and we'll abbreviate that WQS, identify impaired waters, which are essentially, despite current pollution control technologies and all the other controls that may exist and have been implemented since we'll put it that way, that are being implemented and or available to be implemented. Despite all those, this water does not meet the state's water quality standards for that particular water body. And the standards can change depending on what the water source is being used for. That's part of establishing the water quality standards, is tailoring them to what it is that, what the water's intended to be used for if it were not polluted. And then to identify the impaired waters, and then establish a TMDL, total maximum daily load, for the impaired waters of whatever it is the pollutant involved. So a TMDL is technically related to one substance at a time. So the Chesapeake Bay with phosphorus, nitrogen, phosphorus, and sediments is actually 3 TMDLs. Now, this paragraph I have down below is a little stunning, because this is the entirety of the Clean Water Act's statement about what a state is to do in the process of establishing water quality standards. Literally, this is it. They wrote statutes differently back then. Whenever the state revises or adopts a new standard, such revised or new standard shall be submitted to the EPA. Such revised or new water quality standards shall consist of the designated uses of the navigable water involved and the water quality criteria for such water based upon such uses. So if it's such standards shall be such as to protect the public health or welfare, enhance the quality of water, and serve the purposes of this chapter. Such standards shall be established taking into consideration their use and value for, and then here's kind of the litany of uses: public water supplies, propagation of fish and wildlife, recreational purposes, and agricultural, industrial, or other purposes, and also taking into consideration their use and value for navigation. Okay, that's it. That's all the statute says with regard to how and a state is to establish water quality standards. It's certainly true. They did write statutes differently back in those days. Now, to make this even a little crazier, actually, I'm going to correct that, because I was going to say there weren't even any regulations on water quality standard establishment until 1992, but I'm not totally sure of that, but I can say with certainty there were no regulations with regard to TMDL establishment until 1992. So it took 20 full years. It's because at the beginning of the Clean Water Act, everything was about the point source discharges. I mean, that was such a big revolutionary thing to go back to the sources and begin to try to address them, that 20 years were occupied just doing that, essentially. Now, some people who lived it might have a little different version of that, but it's all now past history, so we can be historians and make sweeping generalizations. More parts of this of these obligations of the states. Every 2 years, the states must submit impaired water lists to EPA, including what may become impaired within the next 2 years, so the life of that report. And then EPA, is for the EPA's approval. Well, I'll just keep going. Now, they are to be prioritized by the severity of the pollution and the designated use of the water body. So, of course, if it's a public water source, it's got a much more stringent water quality standard, or it is to have, or it's supposed to have, rather than if it's purely, recreational, or if it's to produce fish and propagate. I don't know if the propagate wildlife is the right word there, but in any event, then it's a higher standard than recreational use, but not as high as a public water source. So that's kind of this sliding scale of the water's intended use, and then the water quality, and then if it doesn't meet the water quality standards that the state was required to set up back in the original or in the Clean Water Act, then it's an impaired water. Now, if there is, for every impaired water, the state shall establish total maximum daily loads of those pollutants that are involved in that particular water source. But the statute doesn't actually say when that's to be done. It is not simultaneous necessarily with when the water is first included, or the waterway or the water source is first included on the every 2 year impaired waters list. And that it led to lots of litigation, which we'll talk about a little bit later. Okay, so now it does say EPA has 30 days to approve or disapprove a state's impaired waters list. And if it's disapproved, then EPA has this timeline for establishing impaired waters essentially on their own, because the state, didn't do a good enough job. And it does talk about EPA establishing TMDLs. And then there's a process for publishing public comment on them, and then they're made final, et cetera, et cetera. But of course, EPA doesn't really employ the concept very often of a total disapproval, because they don't want to get into this other game of having to do these things and impose them on the states. At least that's not the preferred way of doing things. And we'll have a session on the Chesapeake Bay TMDL where we will tell the story of what happened in PA, but in any event, or what happened at the Bay, I should say. Now, here's the site to the regs. The regs are less than 3 pages long, and it took them 20 years to do them. And that's for all of those duties that I outlined for you that the states are to perform. Now, they were once revised in the year 2000. Most of us, might not remember that. I don't remember that, because I was, In private practice at that time, I vaguely had a little awareness of all of this going on. But the bottom line is these changes were so controversial around that time. And this was the transition between the end of the Clinton administration and then the beginning of the George W. Bush administration. But they were revised in 2020, and then there was so much hubbub and controversy about them that the incoming George W. Bush administration completely withdrew them. And, so it went back to the 1992 versions, and that is what we still have to this day. This little tiny section, it's tiny, and all it does. And some government lawyers, if we have any on the line here, as I was at one time, it's basically just a recitation of what the statute says. That's sort of the easy way to write regulations when there's good reason sometimes to do it that way. But that's kind of shocking. Okay, now I have a couple of graphics here that try to illustrate, and this is really tough because I understand the type is very small, but this kind of illustrates this entire process that's set out for the TMDL establishment. So up here, and it's going this way, the direction of the arrow, sort of at this downward diagonal for no good reason, really, just because, I don't know, going, completely horizontally would have fit on my slide better. So apparently that wasn't the way to do it. So anyway, number one up here at the very top, define the water quality goals and set the water quality standards. That was number one on the list that I gave you of what the states were to do. Monitor, compile data and information to assess conditions of the water bodies. You got to have your impaired waters list eventually, so you got to do that first. And then you report to EPA the quality of all waters, and you identify those that do not meet the water quality standards, i.e. an impaired water. And then you submit to EPA for approval the list of the impaired waterways, and you identify which of those that will need a TMDL. Doesn't say you do the TMDL. Then the concept, as intended or as designed, was that you would then develop the TMDL. It says calculate level of pollutant reduction to meet the water quality standard, and that's the TMDL. Then you do two things. For point source discharges, you take the permitting system and you adjust your permit criteria and allowances and the effluent limitations and everything to essentially achieve those TMDLs to the extent that you can. And you have to allocate how much is a point source, origin, and how much is a non-point source origin, and then you allocate for the permit holders, the point source people, what their responsibility is by changing the conditions in their permits to that if they are discharging into the watershed of one of these impaired waters. Then you do some non-point. This is where the tricky stuff starts. Implementing water body restoration actions is what this box says down here, and that's for the non-point source people, or I shouldn't say people, because non-point sources is all of us. It's a collective. There aren't individuals necessarily responsible for the non-point source. It is all of us. If you want to say we all own the rain and we all own the air, or if you just want to say it's out there and none of us own it, whichever you want to say, the bottom line is this is not a individual culprit process. This is a collective process. And so that makes this so different. And of course, the non-point sources are, by definition, they're tricky, they're invisible, they are things that have convoluted and strange pathways. How do these things get in the water through non-point sources? All kinds of ways. And it's like water, it just goes, and it's air, because air is dropping chemical compounds all the time into water. And then you monitor the progress towards meeting the water quality standard. Hey, what's missing from here? Enforcing, trying to do something when you're not getting a progress towards a water quality standard. That's what's missing here. And I tell you that if you look at the Clean Water Act and you look at the TMDL provisions, there's nothing in there. Doesn't mention anything about implementing this bottom stuff down here. Is all kind of intuitive that, oh yeah, that's what happens. But there's nothing in the law that says what happens if those things don't happen. And even what happens if you delay for several years developing your TMDL. Well, lawsuits have attempted to try to force things, and sometimes it's worked and sometimes it hasn't. So the bottom line is there was a big hole in this statute. And then this is the same exact thing, essentially just done in a completely vertical way, but it's conveying the same basic information. Now, here's a couple graphics that also do some things which can be helpful to understanding this process. Here, these two at the top are basically the same thing, just with different labels here and there. Certainly across the top of this gray one, but impaired waters go through the listing process, then the planning process for a TMDL, as you see here. Then the implementing is like permits for the point source people, best management practices or BMPs for the non-point source, identified and I don't want to say suspected. The best evidence is that operations who are contributing in some appreciable, detectable way, perhaps, or maybe that's not necessarily that detectable, to that particular substance's existence in the waters, trying to encourage them to employ BMPs. What's also missing here is that very few states mandate to the property owners that they must do X, Y, and Z, but as required, or as a legal requirement of the law to implement these BMPs. That's not how this works. And now you see a little bit of stuff going on in Europe these days, where farmers are up in arms and taking their tractors into the cities and doing all sorts of public displays of displeasure over that exact thing, the mandating of various measures to reduce non-point source discharges into their waterways. That is one of the things that's driving all these farmer protests in the Netherlands and France and those areas. And that's not what we do here, or at least we have not begun to do that here anyway. So that's that. I sort of addressed that before. That's this difference between the collective obligation and the point source obligation creates some issues here. And then the monitoring, tracking, improving, and recovery. Well, the law doesn't even just talk about that stuff. That's basically just this intuitive, well, yeah, sure, we got to do that because we set all this other stuff in motion. We got to measure what's going on, and there is the continuing obligation to report to the EPA if there's if improvement is being had. But if improvement isn't being achieved, there really is the law is silent on that. So here's another a graphic of the same thing that we looked at in the last two, but different ways to look at the same thing could sometimes help. This is showing you something interesting this is from 2009. This is a long time ago, but by that point, there had been over 37,000 TMDLs completed. And then this, the graph shows you as time went on, the numbers of TMDLs, and I think the red here is the cumulative total of them. The blue is the per year total each year. And then here's the cumulative total as time went on. So this is in the tens of thousands, and it, remains, this was 2009. And, this was a busy time, of course. And it may be that, the per year numbers, if we look now, would be not, quite as a continuing steep grade of the nature that it appears here. But the bottom line is we're in the tens of thousands of TMDLs, and that's completed. So that means that there was in fact noticeable improvements, and those 2-year reports essentially led EPA to allow the waterway to be delisted, no longer an impaired waterway. Okay, I'm going to try to speed it up because me, I'm always going too long. This shows you something that gives you insight into of the TMDLs that had been implemented by 2009. 51% of them were non-point source, or were essentially attributable to non-point source exclusively. 44% of them were combinations of non-point sources and point sources. And then little sliver that were point sources only. So this is where, essentially, the sewer treatment plants and the city, systems, the government systems, et cetera, as well as all the industrial, point sources. So you see that the problem, as it was up to 2009, and this is a similar trend. I don't have this graph for current day, because a lot of attention to this stuff has kind of fell by the wayside. So you get lots of things, the measuring things back in this period of time, not so much today. But the bottom line is, you see, it's overwhelmingly either partially point source or all points. Excuse me, partially non-point source or all non-point source, and very little of it is all point source in origin. Let's just say. Okay, let me keep going. This gives you a cumulative TMDLs by pollutant. And this is where I put this in here so you can begin to see a little bit about the types of pollutants, because, we're also immersed in this idea of nutrients and sediment being the pollutants that a TMDL is concerned with. Now, there's all kinds of things. Mercury is a huge one. And pathogens, waters that are inappropriate for recreational use because you shouldn't be swimming in them. And of course, mercury probably you shouldn't be swimming in either, but, and then you have various types of, metals, other than mercury. And this is the total numbers of TMDL. So, there's a lot of successes that went, this, I don't mean to make it, sound as if, every TMDL is questionable and, did it work? Clearly, lots of them worked. And so there's some other things, organic enrichment, oxygen depletion that is by some other means other than the results of nutrients, which is what we kind of know about when you talk about algae blooms and that sort of thing, or just pure temperature. And climate change obviously is going to have some degree, some contributing factor as we go forward in perhaps an increase in the number of TMDLs that become necessary due to temperature. But the bottom line is, gives you some flavor of and now this is a longer list of the type of pollutants that become the subject of TMDLs. This was from the same year, 2009, and it gives you the causes of impairments. And there they are, there's a whole list of them. So it kind of gives you an idea. There's a lot of different causes. That other list was just doing sort of the hit parade, the top 5 or so. But there's some of these things I don't even know what these terms mean, to be honest. Hey, we're lawyers, we're not water scientists here. But you get pesticide. There's some that were strictly related to pesticide presence. Salinity, and I'm assuming this means salt waters and various other types of either infiltrating seawater into freshwater or some other things that maybe have an industrial source. I'm not totally sure about that one. Noxious aquatic plants. There's a few that, dealt with that in some areas. So that just gives you a flavor. And you look at the number of causes. The reason why it's so much larger than that last graph, even though it's 2009, is that this is counting the number of causes, and many TMDLs have 2 or 3 causes or 2 or 3 things that are maybe involved, perhaps. So things are counted twice in here, so to speak, in these total numbers in the graph. Now, here's a little thing that illustrates how a dead zone starts, or is created from nitrogen and phosphorus. And I will leave that to your perusal at a later time. I will always say with my PowerPoints, get the copy of the PowerPoint, because there is so much in there that I don't have time to talk about. I have a couple of screens that kind of are lifted right out of a frequently asked questions from EPA, which I think are very, very helpful to understanding some big picture, because sometimes they use wording that is so well done that I'm not going to reinvent the wheel here. So what is a Clean Water Act 303D list of impaired water? Okay, we've talked about that already, but okay. There's a reason I put this in here, and I want to see. I think I've covered the first 2 sentences. And then, yep, okay. Here's the second paragraph is why I wanted to put this in here. This tells you a little bit more of the continuing story of the impaired waters lists. In general, once a water body has been added to a state's list of impaired waters, it stays there until the state develops a TMDL and EPA approves it. EPA, and it actually stays there then because they're monitoring it. EPA reporting guidance provides a way to keep track of a state's water bodies from listing as impaired to meeting water quality standards. In other words, there is a tracking that arises from these biannual reports. This tracking system contains a running account of all the state's water bodies and characterizes each based on the attainment status. For example, once a TMDL is developed, a water body is no longer on the 303D list, but it is still tracked until the water is fully restored. So that just gives you a bigger idea of, how these lists work and why they exist. And part of the original obligation is, a state has to essentially, create a data file for every single waterway in their state. What a task that must have been back in the day. All right, now, how do states identify impaired waters? States may use any number of ways. This is that thing that I was telling you about in terms of the water quality standards being so poorly described in the statute. Anyway, states may use any number of ways to determine whether or not a water body meets the water quality standard. However, federal regulations say states must evaluate all existing and readily available information in developing their lists. This means the states cannot elect what data and information they use and purposely disregard other data. Okay, we get it. EPA's regulations contain a non-exclusive list of information that must be considered. Okay, and actually, it's a very vague list. I'll put it that way, because literally the 3 pages of regulations is all we have. Excuse me. What do states need to submit to EPA? Okay, this has a little bit of interesting expansion of what I've told you up to this point. Okay, so in addition to the 303 list of impaired waters, they're also required to submit a section 305B. Now I'm talking like an environmental lawyer. Water quality reports to EPA. The 305B reports provide information on the water quality status of all waters in the state. This is that tracking, concept that I'm just telling you about. Whereas the 303D list is just a list that's a subset of impaired waters. Now they're both due at the same time, April 1st, every other year. And so now it's kind of a single report to the EPA of, here's all our waterways, here's the status of them, and then here's the ones that were, that are on our impaired waters list, and the ones that had TMDLs go off the impaired waters list, but they're still in the EPA database. Now, EPA approves or disapproves the 303D list of impaired waters. If EPA disapproves the state list, EPA is required to identify any additional impaired or threatened waters for the state. Now, again, that's the thing that, EPA doesn't like to do that. They like to send it back to the state and say, here, you do it again. In most of these circumstances, EPA partially approves and partially disapproves the list because some waters have been omitted and adds these waters to the state's list. So that's their way of sort of getting out from under, a bunch of orders of which states are going to be declared impaired. They send it back to the state and tell them to do it. And the bottom line is EPA doesn't have all this data. Like, they don't have independent data on all these waterways other than what the state has. They don't go, how would a state agent, or excuse me, a federal agency be able to do its own independent sort of verification of what the state filed? Just not possible in most instances. So, okay, keep going. This is actually a good slide to understand. And so I might take a minute or two to talk about this in a little more detail. Okay, you get the, let's see. I'm gonna jump down, but I just want to see where I want to jump into. Okay, now here's how you essentially develop a TMDL. This is a good explanation. All contributing sources of the pollutants that are at issue are identified, and they are allocated a portion of the allowable load that usually contemplates a reduction in their pollution discharge in order to help solve the problem. And so in other words, whether it's a point source or a non-point source, they get an allocation of how much of that particular pollutant is, are they going to be determined to be responsible for reducing. Natural background sources like, air deposition or, other, atmospheric and, contributions, shall we say, are supposed to be taken into account as well as seasonal variations. Obviously, if you have a place that rains all summer and it's sort of like Seattle or something, and a margin of safety, they're supposed to put in a little bit of a sort of a buffer there, or a little extra in case their calculations are off. The approach normally used to develop a TMDL for a particular waterway consists of 5 activities: selection of the pollutant to consider, estimation of the water body's assimilative capacity, meaning how much of this can this water body handle, the loading capacity, it says here, estimate of the pollutant loading from all sources to the water body. In other words, how much are they over their loading capacity? Analysis of the current pollutant load and the determination of needed reductions to meet the assimilative capacity, meaning how much do we have to reduce to get ourselves back to what this waterway could handle and meet water quality standards. And then the big one, allocation with a margin of safety, a little bit of a margin of error, of the allowable pollutant load among the different pollutant sources in a manner such that water quality standards are achieved. So you digest that for a minute. It's actually quite genius in just spelling it out, and makes it seem very simple, doesn't it? Boy, if only. Now, what happens after a TMDL is approved? This is good too. Okay, so they're generally implemented through, the MPDES permit system. That's the first attack, so to speak, if it's to a point source. Let me see if, this section of the Act requires that the point source be controlled, or the point source discharge be controlled by, adjusting the MPDES permit and the effluent limitations, meaning the quantities of various substances that are allowed to be there discharged at that particular point source. And then non-point source load reductions are implemented through a wide variety of programs at the state, local, and federal level. This is where the rub gets in. This is where the implementation, gets really tough. And that's what we're in the middle of right now. I said I wasn't going to mention the Chesapeake TMDL, but there I go. These programs may be regulatory, not rarely do they make them mandatory, non-regulatory, or incentive-based. In other words, cost-sharing programs, encouraging people to voluntarily do these things with a little, Mr. Green there. So in addition, water body restoration can be assisted by voluntary actions on the part of citizens or environmental groups. Well, we see that in spades right now in Pennsylvania with all of the water quality groups and the money that's coming in, not just the government money to address the non-point source responsibility for what is, the levels of nitrogen, phosphorus, and sediment, but also all these, sort of NGOs and other people. And then EPA has a whole program, the 319 program, as they call it, which provides grant money to the states to fund specific projects aimed at reducing the non-point source pollution. We know well about that in Pennsylvania. So, although states are not explicitly required under 303D to develop TMDL implementation plans, ain't that the truth? That is where one of the biggest problem lies. Many states include some type of implementation plan with the TMDL. When developed, TMDL implementation plans may provide additional information on what point and non-point sources contribute to the impairment and how those sources are being controlled. So that's, you see, that is the, that's what we're struggling with here in Pennsylvania right now, is this idea that, well, how do we implement this TMDL? And the choices and what's going to work and how's it going to be designed, and is it going to be adopted by people if it's not, you know, a government mandate that you must do X, Y, or Z. And, you know, with regard to what might be your contribution to what is the collective stormwater, air deposition, etc. Okay, so that's very helpful, I think. Sounds simple, right? Oh boy. You know, now this explanation can only be stated in this more simple form because it's the product of decades of hard road that's been traveled by everybody who's worked in this area. You know, the EPA, all the water quality groups, you know, attorneys, you know, and it's not been without just massive amounts of litigation. Each step of the way is rife with complexity regarding the science, because there's a lot of assumptions and there's a lot of, you know, leaps of faith being made here about where something, you know, where the pollutant came from and what's going to reduce, and therefore what do we, you know, address to try to reduce, you know, the future presence of that pollutant in that waterway. There's a lot of, you know, question marks and gray area in there. You know, addressing point sources, sure, that's pretty concrete and measurable, but addressing non-point sources is, I put this word in here in quotes, much less certain. That's my diplomatic way of saying, you know, there are those who would say that, you know, it's not, you know, some of it may not even be necessarily backed up by science. You know, now, what is truly the cause of these stubborn, you know, the stubborn water quality standard failure of a particular body of water? Are the steps taken truly achieving reductions? Sometimes we don't know. Are the methods for measuring reductions accurate? Well, how about the measure, and also what would you measure as your baseline contributions? Because if you live here and you know about the Conowingo Dam problem, you know, the entire calculations of the Chesapeake Bay TMDL have been thrown off by the fact that the baseline that was assumed, that certain, you know, the pollutants at issue were newly what's the way to say it, were being newly generated by, you know, those upstream. And then we find out, you know, that nope, actually, there's all this stuff that was generated decades ago, butting up against and backed up at the Conowingo Dam in Maryland across the border, and that, you know, on rain events, it just washes over the top. So it could be sediment and, you know, nitrogen and phosphorus that was generated in 1940, and it's now just washing over the top of the dam. So that threw off, you know, all of the measurements. So this is the kind of stuff that makes this maddening. Administrative problems. You know, water and watersheds don't follow state jurisdictional boundaries. You know, Audrey, tell me how many questions we have. Do we have a lot of stuff to cut? Oh my God, we do. Well, let's do it this way. We're gonna.
Okay, I just have Suzanne O'Neill. The code word is impaired. If you missed it, it's impaired. Impaired waters. And then we do have a couple questions here.
All right, hang on. I'm going to finish up and then we'll get to the questions. There is actually not that many more slides. You know, not only don't the watersheds follow jurisdictional standards, you know, the causes of the failure to meet the water quality standards, you know, don't follow those standards either. You know, multi-district, you know, TMDL coordination is, to put it mildly, a nightmare. Where's the money for states to do all this, to either cause it to happen or, in worst case scenario, compel it to happen? You know, where's the money for all that? And we know that well. You know, stormwater is 100% fungible and untraceable, as is air, both of which are the major depositors of non-point source pollutants in water. So there's just all kinds of problems here. Now, some of them have been, you know, raised in litigation. You know, the 2000s was the heyday. You know, there were challenges, you know, to EPA's ability to compel TMDL requirements where a state failed to do it, challenges to EPA's listing of impaired waters, or TMDL approval decisions, challenges to EPA's promulgation of TMDLs, challenges to the substance and content of TMDLs, all kinds of things going on, which we would never have time to cover here. But it still goes back to, the vagueness of the law and the lack of any mention of implementation and enforcement, leads EPA to do all these guidance documents to states, which, there's many, many, many of them. None of them are the law. So what's actionable in a litigation context when you are dealing with so much that is based on guidance documents? And again, of course, as I've mentioned many times, 303D has no mention of enforcement. What remedies are there for the various forms of perceived failures, whether it's a failure of the state or whatever it may be, or of a certain, non-point source contributor? It could be a failure of the science. It's not working out the way people projected. The projections were wrong, or they were off, or something was unanticipated. The Clean Water Act enforcement text doesn't apply to this. It's all about individual actors in the Clean Water Act. That's about the point source people, not the states and the non-point source contributors. So it just doesn't work. You can't use those enforcement. They're all about permit holders, having their permits altered or changed, or, that's what the Clean Water Act talks about, not anything relating to enforcing this. So it's really, you don't want to say it in a bad way, but it's, make it up as you go along to some degree. That's why the EPA won't say, what's going to happen, in the future, when, benchmarks aren't met. Okay. And there's all kinds of critical reports. There's 4 various oversight reports that raise all sorts of problems with the TMDL program. So will there be TLB reform? You can see crickets. So let's get to the questions, Audrey. Thank you.
Thank you for joining us this afternoon. Our next program is going to be Tuesday, April 15th. That's a dairy quarterly webinar. And then next month in April, our Director Ross Piper is going to talk about Pennsylvania ag exemptions for inheritance tax and real estate transfers. So we will hopefully see you next month. If you have any questions, reach out to me. I'm AAT17 at psu.edu. Have a great weekend.